Welcome back to A Bite from the Money Sandwich, where we provide practical and easy to understand tips and ideas on how to manage your money better so as to let you retire with comfort and on your own terms. Any good life or financial plan has a safety net, as who knows what's around the corner. Planning for the unknown, though, is more than just organising your will, as your estate is more complex than that, and we want to make sure we don't leave any unnecessary legal and tax trouble for our loved ones. Today I'll be talking with Katrina Brown, the Practice Director of Nautilus Law Group. Katrina has been practicing law for over 20 years and is the senior lawyer overseeing the commercial, estate planning and tax division of the firm. Katrina will help you understand this important topic in easy to understand language with lots of practical tips and help. I look forward to hearing from Katrina about what you need to consider and fix today so that you can enjoy a stress-free estate tomorrow. Well, hi Katrina, and thank you for being our guest here today and to share your valuable knowledge on wills and estate planning. Welcome, Katrina.
Thank you, Marc. Pleasant experience. Thank you for having me.
Pleasure. I've known you for a while and know you've got a great deal of knowledge on a range of areas, including things like superannuation and tax. Can I ask why law, and in particular estate planning, attracted you?
I think estate planning is the string that holds it all together. I particularly enjoy helping families plan their wealth, build their wealth, and then plan how they ultimately succeed that wealth. So it's part of an overall service to clients, whether they're mom and dads, commercial business owners, professionals, or investors. It's the part that puts it all together and makes it worthwhile for the whole family.
Yeah, and for the whole family, it really is that safety net, isn't it, that holds everything together.
Yeah, as I tell clients, look, if you're not going to worry about estate planning, then don't bother saving money, because you might as well just spend it all and not even consider what happens with the next generation. But if you actually do care about what happens to the next generation, then you do need to do estate planning properly, because estate planning done poorly will only benefit lawyers or the ATO or the predators of our loved ones.
Yeah, and absolutely right, because the last thing you want is for all your assets, which you've worked really hard for, is to then make, through third parties like the government, make the decisions for those assets.
Oh, that's the worst scenario. And it unfortunately does happen. For example, if a person becomes incapacitated or dies and they don't have a power of attorney or they don't have a will, then if the family can't agree as to who is appointed to stand in the shoes of that person who's either incapacitated or has died, then the public trustee or other government institutions can be appointed, or other non-related parties can step in, and their judgment overrides all others. And that may not be the judgment that would have been exercised or the decisions that would have been made had that person actually had a choice as to who they were appointing and what those decisions were going to be.
Absolutely. And further to what you were saying, I've got some stats here, Katrina, that I'd just like to throw at you. It says 75% of people don't have an up-to-date will. And yet basically, we're all going to die. And another stat that I've seen was that 25% of people who have a will, but 40% have not nominated who look after their kids, because those wills were done before they actually had children. So that's pretty high statistics.
I would almost think that that's an understated statistic. It's a hard decision as to who you appoint to have control over your person or your finances if you lose capacity, or if you die, God forbid. That's a terrible thought process that you have to have. And I think a lot of people would just sooner not have that thought process and not approach estate planning assuming that they'll do it at a later stage. But unfortunately, as we've seen, and especially with the overseas COVID issues, age isn't the dispositive factor on when we die or when we have to have an enduring power of attorney or will take effect. It can take effect tomorrow. It can take effect today. We don't know what can happen to us. There's no certainty. So even if a person is just 18 years of age, they should have an enduring power of attorney, because if they become incapacitated, their parents aren't necessarily the people who will have control over their health decisions or their financial matters. It could be somebody else if there's a dispute over the parents, or if the parents are separated. If there's, if with de facto relationships, quite often the de facto relationship is not defined until people are in a relationship for 2 years. But quite often what I see is even people in de facto relationships aren't necessarily appointing their partner to act as their health attorney or to act as a financial attorney. They want, for example, it could be their sibling or their parent and their partner. And then as the relationship evolves, then it becomes more of appointing the partner. I see parents who become divorced and then they repartner, and I see children who have separated parents and they're adult children and they become incapacitated, and then the parents fight over who could control that child's health or well-being. It's a real problem. They can be there can be simple solutions. Every will and every power of attorney doesn't need to be complicated. The most important part is appointing people that you trust. If you can't make decisions about how an estate is to be divided up, at least make the decision as to who you trust to make those decisions for you. Because if you don't take the time to make that decision will be out of your hands when you need it the most.
Yeah, and I think that's a really good point about people who you trust. It doesn't actually have to be a relation; it could be anyone, but you just need people who you could trust. And I also think if they've got a bit of business acumen about them, so that they can feel level-headed and not get too emotional, because unfortunately it's a very sad time. But you still want people to be able to be level-headed enough to be able to carry out your wishes.
Yeah, I think probably you as a financial advisor of the years that you've been, and I've been in law for 25 years. I've seen some tragic situations. I've had a circumstance where estate planning was actually done for this particular client. Mom and dad appointed the son, very nice guy. The mom and dad developed dementia over time. And the son was convinced that the financial planner wasn't delivering high enough returns. So because his neighbor had been deriving 20% returns with a different financial planner. So that son moved the parents' financial assets into a separate financial manager's control. It happened to be Storm Financial. As we know, the parents lost everything. So quite often, it's not necessarily just the trust factor, but it's making sure that that person, as you said, has some commercial sensibilities, because it isn't just a matter of whether that person is trustworthy or not. It's whether they are informed enough to make the decisions that are going to be necessary. They need to be able to identify where there's vulnerability and predict and address those vulnerabilities. So sometimes what can be a good thing is, instead of appointing one person, like the parents did in that case, appointing their one son, if they had appointed their son and a friend, so that there was at least a panel of people who were actually consulting on those financial decisions. When you're looking at estate planning, there's 3 stages that you look at. You look at if you can't manage your person, so those are health decisions, where you live, who do you have access to. For example, I've had circumstances where I've had battered relationships, where we want to actually put within the documents an express term that certain people cannot have access to that person. So although a power of attorney for health and finance might seem pretty straightforward, there can be complexities to that one. Also, Jehovah's Witnesses have very strict terms about blood products. So an enduring power of attorney for health can address those types of things. Right. You can also use an advanced health directive in some states as a separate document, but quite often your enduring power of attorney will include health powers of attorney, so you don't have to have that separate. The second category is your financial attorney, and that financial attorney would have control over your money and your investments. And that financial power of attorney really has the power to control where you go, because although the health power of attorney might decide where you should go, the financial power of attorney is actually paying for it. And then the third role is really the executor, and that person takes over from the attorney, and that's the person who collects your assets and then ultimately disposes of your assets upon your death. So there's 3 main categories of people who are responsible.
Okay, so you've put a lot in there, so we're going to try and slowly unpack that, because you've just pretty well put everything into 5 minutes. But it is really important, that point, that it may not be the right person for the whole way through, because a lot of people say, okay, if he's the executive, well, he'll also, or he or she, they're the executive. They could also be for power of guardianship, power of attorney. It could be very different people for the different tasks that you need to have that. So it's really important to sort of list what you need and then who is the appropriate person.
Oh, absolutely, absolutely. And that does raise a good point, because the people that you appoint, for example, for guardianship over your minor children may not be the people that you want to have decide your end of life decisions. And they might not be the same people that you would trust with the money, but there might be a combination of them. So if you put on a piece of paper, financial decisions, health decisions, children's decisions, and then you start organizing people that you trust around those three categories, then you're definitely on your way to doing your estate planning. Now,
so
in a lot of states,
sorry, can I just interrupt, because that really important, just to separate. Most people think of going to their lawyer is to just get their will done, which is when you have an executive and you put down your wishes. But this is a really important point, that no, you also need health directives and financial directives. So they're also the power of attorney and power of guardianships that include it, as well as the will. Because a lot of people just go get their will, it seems, and don't, when I ask them, have you got a power of attorney and power of guardianship? And they say, well, what's that? So it's important, if you, as you say, to get the whole picture, you need to have those three areas done.
Oh, there's actually a fourth area, well, a fifth in some circumstances. Yes, and the problem is any lawyer can write a will, but it doesn't mean that lawyer, this is their practice area. Estate planning really is a specialty area, or an area where the practitioner should have significant experience, because there are always changing laws in this space. I have a case right now where the deceased lady, she had been in a relationship, she was married for 10 years to a person. He has children by a separate marriage. She has children, they lived with her. They just happened to be above minority, but not by much. So they were just over 18, not independent financially. She went to a lawyer and said, look, I want to get my estate planning done. That lawyer didn't understand how to read her superannuation statement. And so he just, I think, assumed that superannuation passed in accordance with her will. He didn't do any title searches to look at the property that she owned with her partner. And then she went away, and before she returned to the attorney, or before she returned to the lawyer, she died. Now, in her mind's eye, she had told everybody that her estate was being divided so that her superannuation passed between her two children and her house was passing to her husband.
Right.
As it turned out, because the lawyer who she was working with hadn't told her that the superannuation doesn't pass to her will, the superannuation, which was her primary asset, the superannuation trustee, who is not subject to state law, the superannuation trustee is independent generally of the investment where you put your superannuation in. They decided that the husband should take all the super. And the children said, well, hold on a second. We have proof that mom's intention was that we were going to get the superannuation, and the dad or the husband was going to take the house. And there was actual documentation to prove this, even though there wasn't a will done because the lawyer hadn't finished it. She had made notes on this. And the superannuation trustee said, that doesn't matter. We're entitled to make our own decision. So when you're saying,
so just
it's
on
not
that,
just a will, it's a will, it's a power of attorney for health, it's a power of attorney for finance. If you have superannuation, you look at your superannuation and you make sure that you have a binding death nomination, because superannuation is a primary asset of most people.
Yes.
And unless you make a binding death nomination, the trustee can nominate who it wants it to go to.
So definitely, as part of this, when people think of their estate, they do think of their superannuation as external to that. It's absolutely, you have a beneficiary. So if you pass away, the superannuation trustees will make a nomination. If you don't, they can't keep it. So it will either go to your estate or to whoever puts a claim in. But that's that's say as a husband or a dependent children, but it's important to just fill in that binding nomination and just get rid of it. Make sure the clarity is there and there is no ambiguity and there's not causing issues down the track. So yeah, so it's very easy and everyone can basically do that online for their superannuation fund or download a form and just sign it.
Yeah, and it's really important. My strong preference is unless you intend the superannuation to pass to your spouse, that you make it payable to your deceased estate. Because then when you do your will, if you change who you want to receive benefits from the estate, it's all in the will.
Yes.
And it does create simplicity for families who don't want to sit there and review their superannuation nominations year to year. And they say, okay, look, I want to get my estate planning done. This is the picture I want to have when I die. I want my spouse to take this. I want my children to take this, or I don't want my children to take anything, but when my spouse dies, then we want it to go to our children like this, or it just creates the ability for them to have more foreseeable outcomes if they make the binding death nomination the estate versus the children per se.
Yes, and on most superannuation forms, it will actually give you the option when you say beneficiary, and you could just say, if you want to leave it to your legal representative or your estate, it will actually give you the example of that. So yeah, because they know that's what most people do. So that makes perfect sense. So so we've covered, you're talking about the role of the executive, and probably I've seen the situation if you have more than one. I know you're sort of saying about a panel in case one person's it's not fit for that role. Where is it worth having a third person so that you've got, if there's a tie, there's someone who can break the deadlock?
I'm actually a big believer in a panel of three in every role. So I like a panel of three for health decisions. I like a panel of three for finance decisions. I like a panel of three for executors. That preference comes into being where you don't intend your estate to pass to your spouse, or there isn't, or you don't have one child, because this decision that needs to be made, whether it's your health decision or about what happens to your finances or what happens in your estate, if you aren't there, I see more risk arising where there's one person who gets to make that decision who doesn't have to consult with anybody else. When you have three and you put, look, they have to resolve matters by simple majority, then you know that there's at least a discussion happening and there's at least a consultation process and there's multiple opinions. If you think about it, these people are making decisions about what happens to you when you can't make decisions for yourself. Those aren't simple decisions. So unless it's a husband or a wife or a spouse, or a single child, I really think that there should be a panel of three. Although in most cases, in a deceased estate, the executors have to act jointly, which means they have to act together. You can write into the will that the decision of a minority member is bound by the majority. So I always think putting three is the best.
Okay, and for a lot of people who may be listening to this may say, oh, well, that seems to be a lot of effort, because it could actually end up being 9 different people. But at least if there's 3, people need to realize that even if you feel like, well, I only just have the home, people forget they've got super. They've got usually have life insurance in super, and they've got jewelry. They have other assets. It doesn't take very much before you actually really start growing an estate. That you really do need to have this all properly mapped out in case the worst happens.
Oh, exactly, and that's a component that really needs to be addressed by the clients as well, especially where they have mortgages. A lot of people don't realize that in mortgage documents, there is a crystallizing term which says that if one of the borrowers become mentally incapacitated, or it could say if they're unable to generate the revenue upon which the borrowing was made, that the loan can be crystallized, meaning the borrower or the lender can require the whole of the mortgage to be paid and refinanced at the worst possible time.
Yeah. of course.
Now, there are some hardship provisions that exist, but those are not the types of provisions that you want to rely upon. So really, when you're doing your estate planning, again, it's not just a will. You need to look at what happens if you become incapacitated, and you need to go beyond that as well. And as you said, look at what happens if you become incapacitated. If you have children, you have a guardian. If you have a mortgage, what happens? Do you have insurance? Do you need to go back to the bank and make sure that those terms of hardship apply to that mortgage, so that if something did happen, you do have time to pay down that mortgage, so that there isn't a forced sale? There's a process here. It's not just a will.
Yeah. And from what you were saying there about, apart from just the will, the power of attorney, power of government, can you just explain? Because I know you've spoken about you need someone for your health wishes, someone for your financial wishes, and I know it's also between different Australian states, it's slightly different, but it's the power of attorney and power of guardianship is what people keep saying. You need to have those as well as the will.
Yeah, so an enduring power of attorney for finance is basically the same across all the states.
Right.
But for health matters, some states call it guardians, some call it health attorneys. But that second category as to health matters is an enduring guardian or a health attorney. Some states have advanced health directives in addition, and advanced health directives come in different forms. They go by different names.
Sorry, what can you explain exactly what an advanced health directive compared to why you just have the guardianship?
So the document that appoints somebody to make decisions over your health matters and over your personal matters is either an enduring guardian or power of attorney. Now, some people are squeamish about having a public document include specific terms about what they would want for end of life. So they have the ability to create the enduring power of attorney or the power of attorney for health matters without saying, look, if I am in a coma, I want this, or if I'm vegetative, I want this. If they want to take those directions and not put them in the enduring power of attorney or the enduring guardian or power of attorney, they can actually make an advanced health directive in one of its many forms. And in an advanced health directive, it sits as a separate document which complements the power of attorney or the enduring guardian, which says, if I'm in a coma, I would like this. If I am vegetative, I would like this. If I'm terminal, I would like this. And it can go through things like artificial feeding, artificial hydration, advanced medical care like chemo treatment, bloodborne product use, quite a broad number of areas can be addressed in that advanced health directive. It doesn't mean that you have to have a separate document, because you can actually put those terms inside of your enduring guardian or health attorney. It's just that it gives you the ability to separate them if you want to.
Okay.
I personally prefer using the terms within the actual enduring guardian or the health power of attorney rather than doing it separately. I prefer to have it in one document.
And these are exactly sort of things you would have a solicitor advising you and helping you through this process. So, okay, so we've spoken about will, which is sort of what your assets and where it's going, and having the role of an executor helping what your wishes are for that, and power of attorney, power of guardianship. People also talk about, well, especially if I've got children or adult children, having testamentary trust.
Okay. The testamentary trust is a way of giving your assets on your death to a beneficiary. So when a person dies, when their estate is administered, they have a number of ways of giving it. One way is to give it to them as an absolute gift. So let's say I have two children, one is 18, one is 25. I have assets of $1 million. Here you go, guys. Here's $500,000 each. Away you go.
Which is the standard way most people do.
Which is a standard way of going. Yep. The downside of that is that their predators will be sitting in the wings and can take that quite easily. Another way of doing it is saying, okay, I have $1 million estate. I have two children. I'm going to put that into a testamentary trust. So that testamentary trust could be controlled by the child, or it could be controlled by third parties. The upside of a testamentary trust is, instead of giving cash, it's almost like giving them a bank account. But it's not actually a bank account, because a testamentary trust can invest in just about anything. It can own a main residence that the beneficiary lives in. It can lend money to a beneficiary, and that beneficiary can pay off their mortgage, but then the testamentary trust takes a mortgage back over it. It can hedge shares. It can have anything. And depending on how it's drafted, it can either lock capital or not lock capital. So it could say they get distributions of so much per year, or it might be completely discretionary. But the benefit of a testamentary trust is that, assuming that the at-risk person, the at-risk beneficiary is not in control of the trust at the time of a family breakdown, that trust itself is not a marital asset. So my son Bob has $500,000. He's married to Mary. Mary can claim $500,000 as part of the marital estate, but Bob instead is a beneficiary of a testamentary trust. It's controlled by Bob unless Bob is subject to risk, in which case, I don't know, my brother Tom manages it for Bob. In which case, Mary can't argue the 500 or the testamentary trust, which has a 500,000 as a marital asset. She can say it's a financial resource, which means that maybe she takes more of the financial assets or more of the marital assets that she and Bob own, but she can't get into that testamentary trust. So it's a really good vehicle. It's like an insurance policy that doesn't cost anything each year, except for perhaps the cost of administration, which is really a tax return.
Right. Okay. And, people have built up quite large estates, and we're not talking millions, but, anything, as you said, 500,000, that's, if you've worked hard to build that asset and you're passing that down to your son, in this case, as your example, you want that to be protected. You want to make sure that that goes down and then goes to their grandchildren if need to be. You don't want that split up, and unfortunately, divorces do happen, and you want protection for that. So I can see why the reasons for testamentary trust and why they should be, and they're not expensive, are they? If you were setting that up as part of your will and estate planning.
Remember, estate planning is really you pay for what you get. So if you pay for somebody who does this as a regular basis, as on a regular service, and they understand this inherently, there's going to be a higher fee because they're going to actually do it better. If you hire somebody who doesn't do this, then they're probably going to use a template that they've downloaded from somewhere, and it may or may not be appropriate. So a testamentary trust can be relatively insignificant in terms of cost in the whole estate planning, or if somebody's drafting a very complex testamentary trust, which I do have with some clients, where they want to make sure they want to address key performance indicators, and they want to have distribution directions as to specific happening events and specific investment decisions, then it does cost more. Yep. Yeah. But the actual cost of having a testamentary trust doesn't arise until the person dies. So if you write a will and you have a testamentary trust, there's no cost of it today. And then when the estate is administered, then the testamentary trust is open. It doesn't cost a separate fee to have the testamentary trust. It's just because the testamentary trust has to lodge its own tax return that it then has a quote unquote cost. Yeah.
And, and it's all about value for money. So if it might cost you, I don't know, 2,000, 3,000, 5,000, whatever the cost is now, but compared to the possible problems you may leave, if lawyers through a divorce do that, it could actually be peanuts in actual comparison.
Well, exactly. When I talk to clients and they say, "Oh, I can't look, why bother with a testamentary trust?" I say, "Well, do you insure your car? Because your car is probably worth $30,000 a year. It probably costs you $3,000 to insure it a year." And we're looking at potentially insuring $1 million, $2 million, $5 million. So if it costs $2,500 or $3,500 to do a tax return for the trust, do you think that's a worthwhile investment? Yeah. I really have beneficiaries in deceased estates where they decide not to use a testamentary trust. Even those beneficiaries whose parents were hesitant about would they really want to use a testamentary trust, when you actually sit down with the beneficiaries and go, look, this is what the benefits of the testamentary trust are. I have had very few beneficiaries who have said, look, I don't want to use a testamentary trust, give me the cash. Because once they understand the benefits of it, they're like, why would I want to give this up? Because they can still control the trust. Well, assuming the parents wanted to make sure that they could control the trust. It's the same as receiving it in a cash amount, but it's protected.
It's protected. And that's all that's the important point there. Okay, so now since we've talked about, you were saying, there are different lawyers. One of the things I like is that you should, whether you find a financial advisor, find an accountant, find a lawyer, it's someone you want to build a relationship with. And this is not just a one-off, this should be a long-term, because things change and you'd probably want to see, update your wills, every 3-5 years or whenever there's a major decision.
My preference is at least look at it every 3 years. I have clients who email me and say, hey, nothing's changed. Katrina, can you look at my plan? Nothing's changed in my personal affairs. Has anything changed legally? Can you look at it? Tell me whether. I'll just fire back an email. Nope, looked at it. Nothing really needs to change. I wouldn't review it right now. Or it might just be, just send me an email that confirms that you're happy with the current design. I'll put that with your security packet, and that's what is done. Certainly, if somebody passes away or somebody becomes disabled, that estate plan should be reviewed. Even if the estate plan already says, look, if Bob loses capacity, then Mary steps in for him. If Bob loses capacity, you really should still come in, because it might be that now, in addition to Mary, we have George, and so we might take and add George right away. So
Yes.
Certainly if there's any change of circumstances, there should be a review, but in general, every 3 years. And estate planning shouldn't be done in isolation. You really shouldn't go, okay, I'm going to call up Joe Blogs and I'm going to make an appointment to do my will. Because again, it shouldn't just be a will, but I'm not going to just do my will without talking to my accountant or my financial planner. Because a lawyer who does estate planning without looking at your tax return, without looking at how your financial returns are structured, is doing a great disservice, because the clients sometimes misunderstand who holds the assets or who could control the assets. For example, I would say at least 50% of clients who come in think superannuation is part of their estate.
Yeah.
Now, if I just accepted and they said, oh, I have $1 million, and I didn't say, where is that $1 million? Then I wouldn't get it right, because I wouldn't say, go to the superannuation and get a binding death nomination done. So really, clients should be talking to their accountant and financial planner as well as the lawyer when they're doing their estate planning, to make sure that all three are working together.
Yeah, no, I think that's a really good point. From an accounting point of view, he's going to look at you from a tax, and so could have a very different way you should own an asset. And you're doing it from an estate planning, how that asset should be owned or documented. And so if you don't talk to each other, could be absolutely making a serious mistake there. Okay, so someone who's got a will, realizes that they need to upgrade it. They should get their whole estate looked at, and we've talked about the wills, testamentary trusts, power of attorneys, power of guardianship. So now we want to they make a decision, but they don't know anyone. They don't know anyone. Like I always say, you should ask your friends or people you might know, someone who's had a really good experience, who's built a relationship with their own estate planning lawyer. But if it wasn't someone, no, my friends don't know anyone either. How can someone look for an estate planning specialist?
Well, I'm assuming you're saying talk to your friends, talk to your family, and your accountant and your financial advisor.
Yes.
So assuming that none of them know, then there is an organization called STEP, STEP, and it's an organization it's a Society of Trusted Estate Practitioners, and it's an international body. So we have to have minimum standards to become a member of STEP. Okay. So they could look at the website for STEP. They can do searches of their local law society page in terms of other practitioners in their area who work in the estate planning area. You generally don't want to pick somebody off of the yellow pages without making sure that they actually do have experience in estate planning, because estate planning is not just downloading a template, filling in information. It's actually being able to analyze. Yeah. So you don't want to find the cheapest option. Definitely. And you don't want to find the easiest option, because quite often the solicitor you can't get into is the solicitor you want.
Yeah. And so I think that's a really good point about, you don't just want a lawyer who can do 100 different things. You want someone who is an estate planning specialist, who's got 5-10 years experience as that specialty. So at least, if you're ringing up a law firm, say, well, okay, who are your estate planning specialists? And then you can do that. Okay, it's a good start. One of the things I also find, and you must come across this as well, is that when I actually talk to people about, okay, you've got your will, you might have power of attorney guardianship. Where are they? Where do you actually keep those documents? And secondly, if something happened to you and your partner, do your adult children know where all these documents are? You must come across that a lot.
Oh, so much. We as a firm keep a fireproof a safe offsite, which is fireproof, with all of the security packets for our clients. And we also have 3 cloud servers and 2 local servers where we store everything too.
Right.
But there is no national database that you can search. So if you don't actually know who did the documents, you might never find the original. So it's always a good idea for there to be some kind of family repository where the family says, look, everybody's going to put their estate planning documents here, and maybe it's a cloud server and everybody has access to it, and it might be password protected, or it might be, look, everybody, I have my security documents in my safe, or everybody, so there's communication as to where those documents are. A will should not be circulated around the family. A will, there should only be one copy of a will. The original should be kept with the solicitor or kept with the client by themselves with maybe one copy, and that should be held by the client. But enduring powers of attorney, advanced health directives, they can be circulated so that people who are actually appointed under those documents can actually have copies. Right. And generally, if you've done the enduring powers of attorney with one firm, you're going to have done the wills by that firm. So at least if somebody's got the enduring power of attorney, even if it's a copy, they should have a reference back to the solicitor who did the will. It's so important to have some system where this is communicated. And I am surprised that in more families, this discussion doesn't come up. And maybe it's just weird that in my family, death and dying does come up. And, hey, just to make sure everybody knows if I die, I want this, or if I'm incapacitated. So it's a very open communication in our family. But I think in other families are like, I'm not going to talk about my death.
Yeah, it's a minority. From being and talking to clients for 30 years, it's absolutely, people find it very difficult to talk about between the husband and wife, but definitely not between their adult children. And sometimes they like to actually keep it hidden and don't want to share that. And I just think it's absolutely the wrong way to go. You do need to let them know. You don't need to know what the details are, even though I would. I feel you should, but as long as you know where those documents are located so that you're not causing people a problem. And yeah, if it's been updated, when the latest version was. So I think that's a really good tip for a lot of people, is that, yeah, as you said, having a depository, online or somewhere that everyone knows about is important. Okay, well, we've actually, covered a lot today. And so thank you for you, Katrina, for being our guest today. One of the things we actually always ask our guest as a final bite is, what's the best piece of advice you've ever heard?
To acknowledge you're going to die.
Right.
Because it's not until you acknowledge that you can have a demise that you accept that there's a problem that needs to be solved.
Wow. Yes. Yeah. No, I think that's very important.
Because I can tell you to write a will, I can tell you to do a power of attorney, I can tell you what's going to happen if you don't. But if you don't actually take into your mind's eye that you will die, there'll never be a point where you make it a priority. We all need to make it a priority. And it's not about us, it's about the people we love.
And it's about the people we love. No, well said. Well, thank you, Katrina, for being here today and sharing your valuable insights in this important area. I'm sure the listeners would have taken a lot out of that. So thank you.
Thank you, Marc.
Thank you for listening to today's episode. If you'd like to know more about estate planning or help find an estate planning practitioner, visit stepaustralia.com. Or to know more about Katrina and her law firm, visit nautiluslaw.com.au. You can also email me on admin@themoneysandwich.com or visit the website, themoneysandwich.com, if you have any questions or want to know anything more.
Want more practical, easy to understand tips and action lists to help with your money stuff? Buy my book, The Money Sandwich, available now on our website, themoneysandwich.com, as well as major online retailers. As with every podcast, this information is not advice, as not personalised to your own situation, and past performance is never guaranteed for the future. What we are trying to do here is provide tips, coaching, and education to help improve your money knowledge, which we believe can only be a good thing. See you next time when we take another bite from the Money Sandwich.